Okay, tonight our speaker is my friend John Gunn. We're happy to have him here tonight. John represents individuals and businesses in a variety of matters ranging from complex business litigation to minor probate proceedings. He recently represented a large corporation with respect to its claims and defenses related to disputes arising from a multi-million-dollar sale and purchase of a number of nursing homes. So he works on some really big stuff and he works on some small stuff. So he does it all. John has tried cases in several counties and has successfully litigated matters in probate, civil, equity, and administrative courts in the state of Missouri. He's also successfully argued matters before the Missouri Court of Appeals and has assisted in the successful litigation of matters before the Missouri Supreme Court. John got his BA from Villanova University. He earned his law degree from St. Louis University School of Law in 2000. He is a member of the Missouri Bar and serves on the Missouri Bar Board of Governors with Nancy and myself. He's also active in the Bar Association of Metropolitan St. Louis and a former president of the Lawyers Association. He lives in St. Louis County with his wife Monica and their son Nora and their daughter Nora and their son Liam, who are very adorable, I can tell you. And so without any further ado, I will turn the program over to him.
Thank you very much, Jen. We talked before we started about how old that bio is. She had to skip most of it, and it made me sound way more important than I am now. Apparently, I used to be a big deal. So I'm going to talk to you guys about non-probate transactions. So a great deal of what I do is estate planning. And in estate planning, one of our core focuses is the avoidance of probate for a variety of reasons that I'll go into. But I'm going to start with some of the more simple estate planning techniques and things that you can do and what some of the risks are, what some of the benefits are. I may go in different directions from time to time. I'll do my best to sort of try to keep the blinders on and go straight ahead. Forgive me if I don't. But I've got the outline that you have in front of me is the outline from which I'm working. There are a couple errors in there that I'll correct. I really don't expect that I'm going to get to all of it. The last section I have in there is actually about trusts. I don't think I'll get there. If I do get there, that's great, because most of the estate plans I do are going to involve trusts. But I'm going to talk to you about the stuff that basically doesn't first. So estate planning in a general sense, the clients that I meet with, what are they primarily trying to do? Well, primarily, as I said, they're trying to avoid probate. The cost of probate is probably the number one reason people want to avoid it. It can get really, really expensive. There is a statutory section in the probate code that allows for, it actually provides that there's a minimum presumed fee. And that's what you see right there under 2A1. So it's 5% on the first 5,000, 4% on the next 20, and so it's a declining percentage on an increasing dollar amount. But for a $1 million estate, and let's face it, $1 million ain't what it used to be. For a $1 million estate, the fee is $26,550. Now that is the fee for the attorney, and I say times two because the personal representative who's appointed by the court gets the same fee. So great for me, not so good for everybody else. So when I'm talking to people about estate planning, that's really the core of it. I mean, there are some people who charge a lot more than I do for estate plans, but nobody's charging that. So it's the cost of probate is really the first thing. Autonomy is something else. Once you're in probate, this is the probate code. There are some other statutes in here too, but it's cumbersome. And any issue that's in probate for any reason has to be administered pursuant to the code. And the code is going to set all the parameters and all the rules and all the obligations. And just to back up a little bit, when I talk about probate, every circuit court in the state of Missouri has a probate division. In St. Louis County, in the city of St. Louis, and in St. Charles County, and in Jefferson County, so just thinking regionally, all those circuits have a probate judge, where that's all they do. They do probate. We have commissioners in St. Louis County and a commissioner in the city of St. Louis that all they do is probate. In the more rural circuits, they have an associate circuit judge who probably does probate, but all of the probate for that circuit, but they do a lot of other stuff too. What goes through probate is decedents' estates. So if the court has to get involved in order to appoint somebody to authorize them to go collect the assets of a decedent, that happens in the probate division, pursuant to the probate code. In the event of incapacity or disability of an individual, disability meaning they can't manage their financial resources, the definition's in here, I'll get to it in a little bit. Incapacity meaning they can't make decisions for their personal care. Those appointments of a guardian for the personal care of an individual, a conservator managing the assets of an individual, those appointments are also made by the probate court. So when I talk about probate, I'm talking about just about anything that's going to be handled by that court. So when I talk about autonomy, I'm talking about you don't need this book. You don't have to go to court to ask for permission to do anything. You don't have to have a filing fee. You don't have to do this, do that. You can make these decisions, these estate planning decisions, so you're going to avoid all that headache and heartache of trying to go through that. The second thing is the speed of administration. Probate in a decedent's estate context, which is primarily what I'm talking about, in a full probate estate, it will take a year, typically, to finish the administration. Some of these techniques that I'm going to talk about can be done as soon as there's a death certificate, and it's over. That might be a week or two. So speed of administration is something also that avoiding probate generally will assist with. I'm going to mention trusts occasionally just because I don't want to get into them completely, but most people these days do have trusts. It's just that's not the type of vehicle that I'm really talking about. But trusts also allow flexibility. And when I say contract-based planning, I'll talk about that in a little bit too. Mostly that's going to be beneficiary designations. So avoid probate. That's the first reason people want some sort of estate planning. Beneficiary plumbing. I refer to what I do as plumbing with some frequency because it's a lot of what I do. I'm trying to plug leaks, make sure things are going to get where they're supposed to get, and that they get there in the most efficient way. When I talk about beneficiary plumbing, I'm talking about that the people who are supposed to receive the assets receive the assets, and that contingencies that may impact whether that's the person who ultimately is going to get it or not are addressed and remedied. And so that if order of death concerns, and again, we'll get to this in a second, I'm still giving you an overview, it's just long. Let's face it, none of us know when we're going to die. We just all know that it's going to happen. We have notions, because we're human, of thinking that older people die first. A lot of us think that in a married couple, the man will die first. It just doesn't happen that way. So, even kids, grandkids, they could all go before we do. We don't know. So beneficiary plumbing is something that estate planning really should address to make sure that those contingencies are accounted for, to ensure that everything gets to where it's supposed to go. The estate tax applies to almost no one. Estate tax, in order for anybody to really be thinking about it, you got to have about $5 million. I don't have $5 million. So very few clients of mine are going to get to the point where they need estate tax planning anymore. And typically with married couples, there's a new thing called portability where a surviving spouse can use whatever estate tax room their deceased spouse didn't use, and now they've got almost $11 million worth of space in which they can transfer to the next generation without incurring a tax. It very seldom comes up. So, I'm going to talk about some of these vehicles that can be used to transfer wealth or property on death. And these are simple things that typically lawyers are not really needed for. They can be done at banks. They can be done, the forms are simple, and if you do go to a lawyer, they better not charge you very much. So joint ownership. we've all encountered joint accounts. I mean, joint accounts, you have a bank account. I have any number of clients who have bank accounts and they put a child on the bank account with them. It's a joint account and they can do it for any of a variety of reasons, but it gives full legal access to the money in that account to the person added to it, irrespective of whether they contributed any of that money to the account. So if my mom's got an account, say it's a brokerage account that's got $50,000 in it, and she adds me as a joint owner, I have every right, as soon as I'm on there as a joint owner, to go into that account and withdraw money. Now, if she contributed it and I didn't, the bank is going to give me the money. She might be able to turn around and say, well, wait a minute, that was mine. You're going to have to make up for it. And I say maybe because those legal cases are kind of tough to make. But the access is there immediately upon somebody being put on one of those accounts. So I say there's no accountability. There's no accountability for the bank because they have to let that money go. And the person who does take it, they may be accountable, they may not. Some of the benefits, all you basically have to do is go to the bank and add somebody. So it's Patriot Act. They have to have their driver's license. They have to sign a signature card. They're on the account. Checks. A lot of people add family members to accounts for the ease of writing checks. I don't want to write my checks anymore. I want you to do it. I'll add you to the account. Perfectly legal, perfectly reasonable, happens all the time. Balancing the account, managing the assets, making sure that there's no fraud by having the access, being able to call the bank and say, hey, what's going on here? And there's no cost of a full estate plan. I mean, this is a no-cost deal. You walk into the bank and you do it. And when I say no-cost estate plan, when you name a joint owner, of course, part of the deal is that it is immediately, it's not even transferred. It immediately becomes the property of the joint owner upon the death of either owner. So it's last to die. So you can have 5 people on a joint account. As long as the money stays there, which it doesn't because now you have 5 people who can take it all if they want to, but as long as the money stays there, the last one living is going to get every penny of it. Yeah.
On an account like that, if I named you on my checking account.
Please do.
For emergencies.
Mm-hmm.
And you decease, are you entitled to that account?
No. So it's when I say last to die, I mean last to die. So if you name me and I die, it's all your money.
It was mine.
That's all yours.
It was mine to begin with.
It's still all yours. It's still all yours. But let's say you name me and my wife, which would also be okay, by the way. Let's say you name me and my wife as joint owners. I die. You're still joint owners. You die. It's all hers. So it's really last to die. It doesn't. The order is of no consequence. So some of the
Taxed on that, though. You have to pay income tax on it?
No.
Take somebody else's money?
No. It's not income.
It's not income.
No, it wasn't. It wasn't income to him. It's not income to you. So here's some of the risks. Number one, obviously, you're putting a tremendous amount of trust in the person that you might name as a joint owner. They do have the right to take that money out. So you want to make sure that that's not going to happen because the bank will let it go. They have an obligation to do so. You have order of death concerns, which I mentioned earlier, and this will be a recurring theme. If I name my 2 kids as joint owners, and the idea being that that is my estate plan, I know they're going to get that money when I'm gone, so that's just the way I'm going to do it. And one of them has kids, so I have grandkids, and my child dies first. And I don't do anything, the child with the grandkids dies first, and I don't do anything with my account. Well, now I only have one joint owner, it's my other child. Those grandkids are out of luck. So my plumbing sprung a leak. That money is not getting to them now. And that was my intent all along. But I'm not paying attention, and I don't have other language in place in this joint ownership scenario to make sure that they get it. So that's a risk. Sometimes a parent or family member otherwise will name somebody as a joint owner with the concept and the agreement that when I die, you will take my money and you will divvy it up amongst your siblings and everybody will have an equal share. There's no obligation to do that. It's the survivor's money. I'll put you one caveat on that, which is if there is sufficient evidence that I told the person to do that with the money when I die, there might be a constructive trust on it, but somebody's filing a lawsuit and there's litigation going on. Because that person otherwise, and the bank doesn't have to recognize it, has no obligation to divvy that money up. If they do divvy that money up, depending on how much there is, there's a gift tax concern. Because an individual can only give another individual, I can only give Jen $14,000 a year. If I give her any more than that, I got to file a gift tax return. I'm not going to pay any tax because I've got $5.5 million I can give away before I have to pay any tax, but I got to file a return, technically. So $14,000. So if I have my two kids and I name one of them as a joint owner and there's $50,000 in there, that child now has that $50,000 and they have to give $25,000 to their sibling, well, they're going to have to do it over 2 years at least. Otherwise, they're triggering an obligation to file a gift tax return. So that's another risk.
The first person doesn't have to pay taxes.
I don't think anything that I'm going to talk about, there was one thing that I'll talk about where income taxes are going to come into play. None of this is income tax. Because if it's not income to the decedent, it's not income to the recipient. And a lot of times when we talk about probate, a lot of my clients will come in and say, well, I don't want to pay all the taxes. Well, I can't. The taxes are going to be the taxes, but the only taxes that there will be is if your decedent had earned income before they died and no tax was paid on it yet, yeah, somebody's paying tax on that. If there's an estate that's pending and it earns interest or dividends, yeah, somebody's paying tax on that. But the only tax on a transfer from say it's $100,000, the only tax on a transfer of $100,000 from person A to person B is going to be a gift tax or an estate tax, not income. It's not income to person B. I'm going to get to an IRA. That IRA is the only thing I'm going to talk about where income tax is an issue. And it's when we.
If I want to give somebody $100,000, I just open up a bank account in my name and put him on it, and then there's no gift tax.
Oh, no, there is. That's a gift. There won't be a tax unless you've already given away $5.1 million.
But I don't have to file
You're supposed to file a return if you give any individual in one calendar year, individual to individual, a penny over $14,000.
I understood that, but I'm not giving it to him, I'm just putting it
That's a
in a
gift.
joint account, right?
Oh, in a joint account? No, that's not a completed gift yet.
I open
Right.
up a $100,000 account and put somebody on there as a joint signature, and they can write a check.
They can write a check. If the IRS ever came in and audited that account and it turned out that all that money was being used for the joint owner that you put on it, they may look at it as a gift. They can still audit you and say, no, that's a gift. We can't. If it looks like a duck and walks like a duck, it's a duck. If you die, the estate tax would be involved. Because if you contributed the entire $100,000, the estate tax now would adhere to that $100,000. Not unless you give away, yeah, not until you trip that 5.2, 5.4. Okay, so a lot of times people think that they're going to use some of these vehicles and say, okay, well now I've got this enormous credit card bill. What I'm going to do is I'm going to put my child's name as a joint owner on my account and the credit card bill goes away. No, it does not. Does not go away. There's a part of the probate code that says, it's actually not in the probate code, but one of our statutes says that if the money was available to you to pay off a debt when you died, your creditors can still get it. There's a procedure that allows your creditors to still get it. So your creditors' claims are still alive and they can still get that money in a joint ownership context. Now, something that's not in there that I don't know why I didn't put in there, if a husband and wife hold property jointly in Missouri, it's not called joint property anymore. It's called tenancy by the entirety's property. And in tenancy by the entirety's property, the creditor of one of the spouses cannot get to it. My dad always called it the amiable fiction of marital unity. You are one person, so that if you hold an account together as husband and wife, and the wife goes up and runs up her credit card bills, that credit card company is never going to collect that asset. They can't. So, yeah, that's good for you up there.
John,
Yeah,
I forgot to ask you earlier. If you can repeat the question.
yeah, I'm sorry. I meant to do that.
You pick it up on the video.
Certainly. The comment was to please repeat the questions, which I didn't do.
I forgot that.
Yeah, no, it was my fault. So I wanted to define disability and capacity because it's going to come up a little bit. And disability, by the way, is another one of these risks. If you have a joint owner, and it's less of a risk on in a joint ownership context, but if you have a joint owner on an account, for example, my grandmother names me as a joint owner on her account because she doesn't want to write checks anymore. She becomes disabled. Well, I still have the right to write her checks, okay? So I don't need to go to probate to get control of her checking account because I'm on it. I have that right. However, if somebody goes to the probate division because she needs a guardian, one of the questions the court is going to ask, and that's going to have to be included in the petition file with the court, is what assets does she have? As soon as the court knows she has assets, the court's going to say, well, we need to be able to see that too. So we're going to pile it all into probate. It's all going to be managed here. You, guy, joint owner, see you later, alligator. You stay on there, but don't mess with that account. It'll still go to you if there's anything left when she dies, but you can't take anything out. So I'm going to talk about disability and incapacity briefly because they're defined in the probate code, and I'm going to talk about them a couple more times. So when I talk about disability, and by the way, there's a typo in here. It's not 455.010, it's 475.010. And the same is true in sub 3. Incapacity is 475.010.4a. So disability is one who is unable by reason of any physical or mental condition to receive and evaluate information or to communicate decisions to such an extent that the person lacks ability to manage his financial resources. A conservator. So a conservator would be appointed by the probate division to manage the resources of somebody who is adjudged disabled. If, and I talk about how expensive it is. Conservatorships are very expensive because you need to have a bond, which is an insurance policy against the conservator stealing the money or spending it poorly or unwisely. They need to have filing fees. They need an attorney to go to court and ask for permission to spend every dime they spend, and they need to report annually to the court full accounting of all income and all distributions. So conservatorships can get very expensive. Incapacity is, an incapacitated person is one who is unable by reason of any physical or mental condition to receive and evaluate information or to communicate decisions to such an extent that he lacks capacity to meet essential requirements for food, clothing, shelter, safety, or other care such that serious physical injury, illness, or disease is likely to occur, and that's when a guardian is appointed by the probate division. Guardian of the person, conservator of the estate. So I'm not really talking about guardianships because we're really dealing with assets here. So I'm really talking about conservatorships, but I'll talk about disability too. So I already talked about how an adjudication of disability in a joint context could still cause an issue. And I made a note to myself to mention also that jointly owned real estate, you're not staying out of probate for any reason. Because if real estate is jointly owned, you can't write checks out of a house. So it's not, if I put my son on my house with me and I become incapacitated and that house needs to be sold, and I'm disabled and that house needs to be sold, who's going to sign for me? He can't do it. He doesn't get it until I'm dead. So somebody's got to go to court and get the authority to sign for me. Non-probate transfers law. So the non-probate transfers law, when I talk about joint ownership, it is technically not part of the non-probate transfers law. The non-probate transfers law is Chapter 461 of the statute. And it has a lot of very specific provisions. The one that is most commonly used is the transfer on death provision. I say pay on death designation or transfer on death designation. The statute also actually says you can call it either. The law doesn't care. But allows you to designate a beneficiary effective only upon death. So if you've got a TOD designation on an account, somebody got to have a death certificate before they can get that money. The registration has to occur prior to death, obviously. But what that means more than anything is the entity that's holding the asset in the event of a bank account has to have it before death. For an account or anything else that's registered anywhere, you can't just have some piece of paper floating around that says that it's TOD to someone. The bank's got to have it. What the law says is it has to be on an account record, security certificate, or instrument evidencing ownership of property written as part of the name in which the account is registered. So a limited liability company interest, in my experience, limited liability companies are becoming more and more ubiquitous. Just they hold a little piece of real estate. There's a company that doesn't really have anything, but it used to, and now it's got a little bank account. You can transfer on death limited liability interests, limited liability company interests, but the company has to have it, so you're registered with the company. A corporate interest, really, the transfer on death, the transfer on death designation should be on the stock certificate itself. Personal property, you can have it as long as the holder of the personal property does it. A CD at a bank, it's got to be typed on the CD. A treasury bond, I see these all the time, particularly treasury bonds that people have forgotten about. They'll have TODs to somebody who's already passed. So that's a big pain, but we get it, the death certificate, you get it all figured out. Car title, transfer on death, car title. Again, we're not talking about joint ownership. You're not giving somebody access now. They don't get anything. They don't get any access. They have no rights until you're deceased. Car title, for example, it makes selling the car a lot easier. You only need one signature. You don't need two. The benefits are it's a non-testamentary transfer. What I mean by that is you don't need the formalities of a will. You don't have to have two witnesses. You don't have to have an expression of the fact that it is your last will and testament. Most wills have to be, or should be at least, notarized. You don't need any of that. You can go to the bank. You can go to a license office and get your title switched over and just write TOD and something underneath it, get the new title issued, it's done. It's cheap. Once again, this is a pretty cheap way to do some basic estate planning. Wealth transfer from person A to person B. Adding more than one recipient, sort of tough. You're working with documents typically where it's got to be on the title to the account. And if I go to wherever I might bank, and I tell them, look, I want to add my 10 nieces and nephews to this account as transfer on death beneficiaries, they're going to laugh me out of the place. They don't have enough space on there for 10 names. So that's sort of an issue. Risks involved with transfer on death and pay on death designations, order of death. Once again, as I said, you haven't really hedged against that to very much of a degree. If I name my son and daughter as transfer on death beneficiaries, again, and my son's got kids, and he dies before I do, his kids are out of luck. They're not getting anything. I have noted in here that with respect to the Non-Probate Transfers Act, so transfer on death designations and beneficiary deeds, which I get to in a minute, there is a presumption in the statute that says if a married couple hold assets, if a spouse is named as a transfer on death beneficiary or otherwise as a non-probate transfer beneficiary, and the couple is later divorced, the recipient spouse is considered predeceased. So if I name my wife as a transfer on death beneficiary to my car, and then we get divorced and I never change it, she's already dead to me. So she is considered predeceased under the law, so she doesn't get it. So it'll be as if there's no transfer on death designation at all. So the law actually in this particular code does provide some protection vis-a-vis divorce. And I have noted there's no such protection for jointly held assets because that's not a non-probate transfer. In the event of divorce, as a practical matter, it'll be handled, a jointly held account will be handled in the divorce decree. A transfer on death account, it might be mine, it might have always been mine, but I just have a transfer on death designation to my wife. So the divorce decree doesn't talk about it other than I get it, but I never changed the transfer on death. But now we're divorced, she doesn't get it. Was there a question up there? Yeah. So the question is, if there's a car that has a transfer on death designation and it has a debt associated with it, does the debt transfer to the new owner? The answer is no, but that debt is always going to be secured by that car, so it's still going to get repossessed. So there probably will not be a personal liability for the new owner to pay the debt, but if they're driving around in this car that's leveraged and they're not making payments on it or they haven't renegotiated it in their own name, they're going to find it and it's going to get repossessed. Disability, still a concern. For a transfer on death designation, it's only going to transfer upon death. So if the account holder is disabled, nobody's going to be able to access that asset without a court order. So somebody's still going to have to go to court to get appointed conservator. And that's true even to get information regarding the account. So if you don't have a statement, bank's not going to give you information. So if you just want information about the account, even to figure out whether you want to go through the trouble, you probably have to go through the trouble first. Again, still subject to creditors' claims against the decedent. So it's a non-probate transfer. It was available to the decedent to satisfy debts when the decedent died. So the creditors there's still a procedure allowing the creditors to get to it. A beneficiary deed for real estate is also referred to specifically in this Non-Probate Transfers Act. Transfer of title of real estate by deed recorded in the county with the Recorder of Deeds office prior to death of the transferor and effective upon death. Prior to death is in all caps for a reason. I've had cases, more than one, where the deed was not recorded before death and it's an absolute nullity. It doesn't mean anything unless it's recorded prior to the death of the owner. And usually those lead to a lot of unnecessary money being spent on attorney's fees because it is clear as day. There's really nothing to fight over. If the deed isn't recorded before the death of the principal, it's of no use. I have a parenthetical there that the way that the title transfer occurs is the deed's recorded prior to the death of the person who owns the property, saying who gets it when they die. After they pass, the person who's entitled to it can go in and record an affidavit that says, there's a deed, that person died, now it's mine. So it's one piece of paper, it's just a recording of one additional document. Benefits of beneficiary deeds, effective immediately upon death. Once again, you don't need any probate intervention, so you're avoiding all that. You don't need any additional documentation. You don't even need a death certificate, frankly. You don't record the death certificate, you just sign an affidavit saying, yeah, they died. Again, it has to be recorded prior to death. The cost of recording is pretty low. If you want to record a 2-page deed in St. Louis County, it costs about $37. The 1-page affidavit is going to cost about $27. I have written down there a hypothetical, I already gave it to you. I've had, as I said, I've had cases where there's been a failure to record prior to death. I can't say this absolutely because I wouldn't know the facts of any other specific cases, but if a lawyer prepares a beneficiary deed, has it executed, and does not see to it that it's recorded, or does not advise their client that it must be recorded before death, that's malpractice. Has to be recorded before death. The risks of beneficiary deed, disability. Still not going to transfer until death. So if there's a disability, as I mentioned before, you need a conservator. Order of death concerns, if I name my kids as the beneficiaries, those grandkids aren't getting anything. Now there are ways in deeds, because deeds are contracts, so they can include a lot more language. So a lawyer can actually draft into a deed some of those plumbing provisions to account for my son's kids. So I can say that the beneficiaries under my beneficiary deed are my children in equal parts per stirpes. That means if one of them dies and has descendants, the descendants are going to get the deceased child's share. So now I've got some plumbing in place. We're getting there. We're not there yet. But that's a slightly better vehicle because a lawyer can actually draft that stuff in. If you go to the bank and you get one of those transfer on death designations, writing that stuff in, they might let you do it, they might not, and if you do it, they might recognize it upon death, they might not. I don't know. Banks do their own thing. I can't control it. Beneficiary designations on allowed accounts. So I'm not talking anymore about transfer on death. I'm talking more about qualified assets now. I'm talking about IRAs, 401ks, 403bs, KEO plans, profit sharing plans, et cetera. Things that, assets that are funded with pre-tax money. Yeah.
On the part C there, it says prior to death. Prior to death, does it have to be to an individual or can it be to a trust?
So the question is, when I say prior to death, are you talking about in a beneficiary deed?
Real estate.
A beneficiary deed context, does it have to be to an individual or can it be to a trust? It can be to a trust. Sometimes it is. Most of the time, in my experience, when I'm using a beneficiary deed, it is going to be to an individual because in those frankly rare circumstances we're not using a trust, that's what we'll use. Typically, if I am drafting a trust, I'll deed the property directly into the trust. So it's done because that way I'm avoiding the disability issue because I have a successor trustee who's there to act. Nobody has to go to court. Yes.
I wanted to ask you a question about the first earnings.
Mhm.
I have set up with First Earnings for an account, which would be my daughter and then my granddaughters. But if my daughter would pass away, would that go to her husband?
No. Okay. So the question is, by using per stirpes, we love our Latin. By using per stirpes on an account where you've got a daughter and granddaughters, if your daughter predeceases you, will her spouse have any interest? The answer is if your daughter predeceases you and then you die, will her husband have any interest? The answer is no, because when we talk about per stirpes or by right of representation, which is really the other way to trickle down assets amongst heirs, we are really talking about lineal descendants. So lineal descendants would be, well, that's the first way, and then it goes back up if there aren't any and out to siblings and parents, et cetera. But lineal descendants are bloodline. So spouses really, on per stirpes in particular, spouses are not going to participate. Okay, so back to qualified assets. There, of course, is an enormous tax benefit when you name a beneficiary on a qualified account. A spouse can take a qualified account and roll it into their own IRA. They don't have to take required minimum distributions until they reach the appropriate age. It's their IRA, It's the same rules as they apply to you. Done. Spouse, huge benefit. Spouse almost always is going to be a primary beneficiary on any tax-deferred asset. A non-spousal beneficiary also has rights. A non-spousal beneficiary can typically take in a lump sum. They have the option typically to take in a lump sum in 1 year. But if they don't want to, they may be entitled to a 5-year stretch so that they can take it over 5 years. Or they might have the right to take over their entire life expectancy, provided the principal was under 70 and a half at the time that they died. So they can take it over their entire lifespan. Yes, ma'am.
Repeat that last thing that you said, provided the principal was what?
Under 70 and a half. Age of 70 and a half at the time that they died and the inherited IRA went to the beneficiary. One second. Failing to name a beneficiary on any tax-deferred asset, if there's no beneficiary named, all of it's going through the estate. All of it probably will be taxable in 1 year because it's going to an estate and not to an individual. I've had some luck convincing banks that they should flush it right through the estate to the individual beneficiaries and treat it as an inherited IRA. I don't think they need to do that. And when I did it originally, I didn't think they could do that, but they did it anyway, and it was better for everybody else. Okay, there's a question back here on the right.
When you mentioned the qualified account and you said that someone was under 70 and a half, are you referring to the beneficiary or the deceased put that in place before they were 70 and a half?
When I talk about the person being under 70 and a half, I'm talking about the principal whose money it is at the time that they die. So it's not at the time that they name the beneficiary, it's the time that they actually die and the transfer takes place. There was a question back here?
If the IRA is going to adult children, passed on to the adult children as part of the IRA, which is set up at that point, they will then manage that with, can they put it right into their own IRA, or that's how it works? And they then, only till they get to 70 and a half, they can take it out before, but they pay taxes, and that's earnings taxes on IRA, right? Is that how that works, or?
Well, so the question is, as I understand it, the question is if a child, an adult child, is the recipient of an inherited IRA, do they just transfer it into their own IRA and not be required to take anything until 70 and a half? And the answer to that is no. They will at least need to take something in year one. And their required minimum distributions, in the best case scenario, will start year one and go for their entire life expectancy. That's their best case.
Okay.
They don't wait till 70 and a half. An inherited IRA is different. And yes, each of those distributions will be taxable as ordinary income. There won't be penalties,
Right.
but they'll be taxable as ordinary income.
Right, now, so that would be in any case. In other words, if they took it as a lump sum, it's also taxed as ordinary income in that 1 year. Is that correct?
Yes, a lump sum would be ordinary income as well. And of course, the lump sum, the reason that that's not necessarily desirable, and of course, the size of the IRA is going to have some impact. But a lump sum in 1 year is undesirable for two reasons. Number one, it could increase the marginal tax rate because now the income's gone way up in 1 year. And number two, you don't have the benefit of that tax-deferred growth over time. So even if it's 5 years, you're spreading out that lump sum so that you may keep your marginal tax rate down, and you get 5 years worth of growth where you're not being taxed on it.
All right, so that's the first question. Now, I gotta think through that second question, because you raised it on the last issue, I was just remembering it. So if the, I'll tell you what, I'll play with it, and
Okay. Well, we can talk later, too.
I gotta,
Naming a minor as a beneficiary on a tax-deferred asset means that you're going to end up in probate. Now, in the grand scheme of things, is there a whole lot you can do about that? I don't know. I mean, if you've got a trust, typically what I do, as I said, most of the estate plans that I write anymore, there's a revocable living trust. If I have clients who are on the young side, have minor kids, are in pretty good health, I look at these contingencies against which I need to hedge. What is the likelihood that they are going to, husband and wife, both be gone before the youngest is 18? And if I think that that likelihood's relatively low, spouses will name each other and then we'll name the trust as the contingent. And it'll go through the trust. Yes, there's a possibility that the trust gets all that income in 1 year, and either has to push it out to the kids in a conservatorship or has to pay all the tax. Trusts typically pay tax at a higher rate than an individual would. But it's a calculated risk to cover that period of time when those kids are still minors. And then I just encourage clients to remember, look, you need to look at your estate plan again when your kids are adults anyway, because you may have them move into a fiduciary position, name them in your will, name them in your trust as a trustee. And at the same time, we would reassess and maybe change the beneficiaries on those accounts to take the trust out and now name the kids individually. Yeah.
I don't know if you're gonna get to this or not, but when would you recommend setting up a GST?
Well, GST is a generation skipping transfer tax. And it is basically, I'm no expert on GST, but the GST, as I understand it, is a tax on a transfer that skips in a generation. You're not going to hit that unless you're at that taxable estate level with 5.4 per individual, 10.8 per married couple. And even then, you're only going to really need it if there's a trust in which an entire generation is really skipped. And so if there is a trust where a large sum, it would almost have to be a large sum, is being left to grandchildren and skipping over children completely, there should be some generation skipping tax. It should be at least addressed and considered. Whether there are actually provisions in the trust or not, it depends. But I think that getting anywhere near that 5.4 level is when you need, and if there's an actual generation skip, is when it needs to start being considered. So another type of asset where we're going to use beneficiary designations are life insurance policies or annuities. And as with, I didn't mention this, but as with qualified assets, all you really do is you contact your company and they send you a change of beneficiary form. You just fill it out. But you want to make sure there is a beneficiary form filled out, because as with qualified assets, if you've got a life insurance policy with a death benefit or an annuity with a death benefit, and you don't have a beneficiary named, it's all going to probate. It's all going to go through the probate process, and if you don't have a will, it's going to go to your heirs, whoever the heck they are, because they're not determined until you're dead anyway. So benefits, again, it's direct, it's cheap, basically free. You just got to take some time to get the designation form. You can name multiple beneficiaries. Some life insurance policies and annuity policies will have beneficiary designation forms that have a number of slots, and you can assign percentages or you can say per stirpes, but not all do. Everybody does it differently. There's no probate, and it's, as I said, it's a simple form. Risks, order of death, that hasn't really changed unless you get one of those long forms where you can put a lot of beneficiaries or put per stirpes or by right of representation. These life insurance policies and annuities and qualified assets really cannot be subject to the collection of creditors. So I did not list that as a risk in any of those. They're not non-probate transfers. Because they're not non-probate transfers, that statute that allows that procedure to go out and get those doesn't apply. I think the law views it as life insurance proceeds, for sure, are not available to me. My life insurance policy is not really available to me to pay the debts of my creditors. Maybe it is to the extent that it's got cash value. If it's a whole life policy and I'm using it as an investment vehicle, maybe it does, but it's still not a non-probate transfer, so it's technically not in the act. That's an area of the law that we've had some sample cases that just didn't get far enough to the Court of Appeals to make any law to figure out which way we go with it, but it's an area of the law that's not really totally settled yet. These beneficiary designations, particularly with regard to life insurance policies, and I've had these cases too, they're pretty easy to change. I mean, somebody can call MetLife and say, you know, Aunt Judy's got these annuities with you guys. Can you just send over some change of beneficiary forms? Oh, yeah, sure. Okay, well, what's the fax number? We'll fax them to you. Well, I've had litigation matters where all of a sudden you get these signatures and you don't know where the heck they came from. There are no witnesses. That's not Aunt Judy's signature. Aunt Judy was in the hospital at the time. I mean, these are easy to get. So there's some risk for fraud with this type of stuff, the beneficiary designations. And beneficiary designations obviously are going to be used in even the more complex estate planning too. There are some events where you will have an owner of a policy be someone other than the individual, but usually those are going to be estate tax planning vehicles that they're just beyond what we're really talking about here, the GST question notwithstanding. So I'm going to move on to powers of attorney.
John,
Yeah.
question. Earlier in your presentation, moments ago, you said percentage as far as beneficiaries rather than dollars. So you go by percentage of the estate or the trust?
Well, I'm not really talking about estates or trusts in that context. What I'm talking about are life insurance policies
Okay,
or bank accounts. In most instances, I mean, for life insurance policies, you may know exactly what the death benefit's gonna be, but they're gonna want percentages anyway. In fact, most of the forms are gonna ask for percentages and ask for a breakout of percentages.
percentages is by far better than dollar assessed.
Let me get to that in a minute. When I talk about wills, I'm gonna talk about that.
Okay,
And, yeah, we've got plenty of time to get to wills, so I'm gonna talk about that a little bit then. Remind me if I don't, though, yeah.
You buy a life insurance policy for your child when they're very young and they've grown to adulthood, and you're still doing the premiums, you still own it. There's really no beneficiary on that, you're the owner of the policy. So if you're gonna have that child,
I bet you there is a beneficiary on it. The beneficiary is probably you. When you bought that policy, you probably named yourself as the beneficiary. You might want to change it. If there's no beneficiary, it's going to go to the decedent's estate, not yours, and not you. But if there's no beneficiary named, it'll go to the insured's estate when they die. Because in most instances, the law sort of assumes that if there's insurance on the life of somebody, that it's that person's insurance. It's that person's money, the proceeds are. I'm thinking about estate tax returns. On estate tax returns in general, you have to explain to the IRS. You have to list all insurance policies on a person's life. And if one of those insurance policies on the person's life was not owned by that person, you have to explain to them that it wasn't owned by that person and show them that it wasn't owned by that person. Otherwise, the proceeds are includable in their estate for estate tax purposes. So, powers of attorney. Yeah.
Let me know if you're starting a new topic, maybe take the first one.
Sure, yeah. Why don't we take a 10-minute break and everybody come back in? It's a great spot to do that. So I've had a request from a couple people, maybe to fast forward a little bit through some of the stuff I'm going to do and get to trusts. And I love talking about trusts. So is that okay with everybody? I mean, I'm going to talk about powers of attorney. I'm going to talk about wills, but I'm going to do it relatively briefly, if that's all right.
Just one question before you go to that.
Yeah.
So on checking accounts, okay, if you put all the beneficiaries right on as part of the checking account in terms of having that, or do you just put, how would you deal with it? Or would you put the checking account into a trust? I mean, it's part of your trust.
I would. So the question is, on a checking account, would you just add a bunch of beneficiaries or would you put it in a trust? As a default, my recommendation is typically to put it in a trust.
Okay.
Because then you know your plumbing, most of the plumbing in a typical estate plan is going to be within the trust instrument itself. The only thing that's going to change on that checking account, the tax identification number is not going to change. The only thing that's going to change is the name at the top. It'll say the trust instead of your individual name. Now, caveat to that, and I'm jumping way ahead now, I talked about probate a little bit before. A probate estate for a decedent, a full probate estate, requires an application for the appointment of a personal representative. If there's a will, there needs to be a petition to admit the will to probate. Once the estate is open and the personal representative is appointed, there has to be an inventory filed, there has to be an annual accounting, and when the estate is closed, it's got to be, there has to be a final statement of account, proposed schedule of distribution. All this stuff has to be done. There may also be a bond. So that's like I said, it's the insurance policy against the personal representative doing this or that. I forgot where I was going with that. Huh? Well, I am going to talk about wills.
Do a caveat on the checking account.
Yeah. So that's a full estate, thank you. That's a full estate administration. In Missouri, we have a small estate administration. Anything under $40,000 can be done through a small estate administration. Small estate administration is an affidavit signed, assets listed, heirs or legatees if there's a will named, filed with the court, stamped, given back to you, collect the asset. way easier. So when we talk about checking accounts, frequently I'll have clients who will say, my checking account never has over 5,000 bucks in it. I don't really want to change that. I just want to change my big stuff. I don't want anybody to know I have a trust, so I don't want it on my check. Fine. Make sure whatever assets are outside of your trust, keep it, in aggregate, keep it under 40 grand and you're okay. It's not that big a deal. Once you trip that $40,000 threshold, now we got to go through that whole rigmarole and keep the thing open for a year. It's a big pain in the neck. All right, powers of attorney, quickly. A power of attorney is only good while the person is living. It dies with the principal, with one small exception, which is the right of sepulcher. The right of sepulcher is the authority to do with a deceased person's body what needs to be done. Typically, the right of sepulcher is going to be handled in the healthcare power of attorney. The form that I handed out, which is the Missouri Bar's form, it's on our website. It includes right of sepulcher language in it. Most financial powers of attorney are going to be both general and durable. A general power of attorney, really all you have to say is general, and it incorporates a number of things that are listed and delineated in the statute. And it authorizes the agent to act with respect to all lawful subjects and purposes. So if I'm the agent and I give my principal general authority, they can do what I can do, basically. There are some powers that must be specifically delineated. To the authority to execute, amend, or revoke a trust agreement. I can actually give somebody that authority to do it for me in a power of attorney. The authority to fund a principal's non-trust assets into a trust. The authority to nominate a guardian or conservator. We're trying to avoid that, but as I said, sometimes somebody might come in and just open an estate anyway, a probate estate for somebody who's incapacitated or disabled. If that disabled and incapacitated person has a power of attorney that nominates a guardian or conservator, the court will look at that person first to appoint. There are certain powers in a power of attorney that are forbidden, that you may not give authorization to somebody else to perform. Make, amend, or revoke wills, living wills, which is the healthcare directive, or requiring an agent to do anything against their will. Can't do that. Powers of attorney, wills, trusts, there's always a best interest standard. Whoever is serving as the fiduciary always has an obligation to act in the best interest of the person that they're serving. That's kind of an overlay over all these fiduciary obligations in this estate planning and probate context. So that's a general power of attorney. A durable power of attorney is a power of attorney that survives incapacity and disability. The authority does not terminate should the principal become incapacitated or disabled, or if there's later uncertainty as to whether they are living or dead. That later uncertainty as to whether they're living or dead language, my firm believes, must be in a power of attorney in order for it to be durable. If it's not in there, it is gone as soon as you become disabled. Even if there's not a question as to whether you're living or dead, the language has to be there. There's sample language in the statute and includes that. So it's got to, if you've got powers of attorney, make sure they say that or they're not durable, I don't think. Powers of attorney can be either springing or immediate. A springing power of attorney is one that does not become effective until some event occurs. So it sits there in escrow until something happens, and then it can be used. That something that happens is typically the issuance of an opinion by one or more physicians that there is disability or incapacity. A springing power of attorney will protect against fraud because nobody can use it until these letters exist, but it's not very agile. It's not very nimble. It's cumbersome. You can't use it right away. You got to go get the letters, and then you got to make sure you have the letters every time you do want to use it. An immediate power of attorney, pretty obvious. It's immediate upon signing. Very agile. Can be used just because you're out of town or out of the country. Your kid can use the power of attorney to do whatever needs to be done. However, it is more susceptible to fraud because it is immediate right then, and if it floats around, it can be used, and that's that. Power of attorney needs to name an agent. I typically recommend that individuals are named, even though the statute allows for corporations to be named, banks primarily. I know that if I had a power of attorney act on my behalf, I would rather, because I'm still alive, I'd rather it not be a corporation. I want it to be somebody that I know. Co-agents are also allowed under a power of attorney. Co-agents sort of limit agility as well, because now you got to have one or more persons. It's always going to be majority vote, but if you've only got two, they have to act together. So you got to have everybody there every time a decision is made. You can do an either or. In fact, most of the powers of attorney in any of these documents that I'll draft, it'll have a litany. It'll say, I name this person. If that person can't do it, this person. If this person can't do it, that person, et cetera. A power of attorney need not be either durable or general. It can be limited in time, allowing, it's only good for the period of time that I'm going to be out of the country. It's only good for the next couple of years, and they can always be revoked too. And it need not be general. You can have it for a very specified purpose. There are powers of attorney that I've drafted and used whereby authority is given to close on a house because somebody is going to be out of town at a closing. So you can give a power of attorney giving someone the authority to close on the house for you. Another power of attorney that I use with some frequency that's neither general nor durable is the authority, and the statute gives this specifically, if I had a client who left the country last weekend he was out of the country, and he said we need to give power to our babysitter. Easy enough. You can give it to the babysitter for a specified period of time. The statute doesn't allow it to go beyond a year anyway. They can't consent to adoption. Good thing we got the law backing us up on that. So the agent can't consent to adoption, but you can get, as a parent, I could give somebody the authority to take care of my kids while I'm gone without having to go to court. There's a question in the back? Yes, ma'am.
Is there a difference, what's the difference between the power of attorney, durable power of attorney, and living will?
So the question is, what's the difference between a power of attorney, durable power of attorney, living will? Power of attorney covers all of it. So almost all of this is included within the same chapter, 404 of the code, okay? Durable power of attorney just means it survives disability. So just because I'm disabled doesn't mean that my power of attorney goes away. It can still be used. Living will is basically the healthcare directive portion, which I'm going to get to in a second, and that's part of what I handed out today too. And that's the next portion. So a durable power of attorney, and we don't call it a living will in Missouri. Some of our parlance does, but the form itself doesn't use that term. But a living will is basically a healthcare directive. So our statute allows for a durable power of attorney for healthcare, meaning you can appoint somebody to make healthcare decisions for you, and a healthcare directive, meaning these are the decisions I want you to make if I cannot articulate the decisions myself. So it also draws on Chapter 404, as I said. It's in the same part of the code. The right of sepulcher, as I mentioned before, is part of that. So 404 says you can give, allows in a power of attorney to give consent to or prohibit medical care, health care, et cetera. And then 404-800 is called the Durable Power of Attorney for Healthcare Act. Allows you to give authority for withholding or withdrawing treatment, including artificially supplied nutrition or hydration. Allows you to pick whether you want one physician or two physicians to determine that you're incapacitated to the point you can't articulate your own healthcare decisions. We have found in my office that the form that the Missouri Bar has developed is as good a form as any. So I am not going to draft my own form based on that and then sell it to clients as part of my thing. That's why I give it to you. The bar has already done this as a service to the public. And it's a good form. Honestly, I use it in my practice. I don't, unless I'm out of state representing somebody in Illinois, I use that form. It's fairly self-explanatory. It's check the box by initial. You don't sign it without a notary and a couple disinterested witnesses. You want people who are not listed on there as agents. And you need a notary, but those are yours. You can make copies of them if you kept them blank, or you can go to the Missouri Bar's website. You can find them, and there's actually a fillable PDF on the Missouri Bar's website where you can fill it all out, and then initial it later. Yes, sir.
Is this durable power of attorney for healthcare, does it have power outside the state where it was executed?
The question is whether the durable power of attorney for healthcare provides authority for outside the estate where it's executed. If I said estate, I'm sorry. I'm in the zone. The answer is probably. Every state has its own set of laws. Typically, the execution and the articulation of the desires are going to be pretty much the same. Our form references Missouri, I think, once or twice, but that doesn't mean that it's unique only to Missouri. However, there are a number of states, including Illinois, where there's a statutory form. The legislature has actually created a form for this purpose. Our form isn't statutory. The legislature didn't do it. We did it. The Missouri Bar did it. I have found statutory forms in Texas, Tennessee, New York. We don't have one, but if I'm representing people, even if I'm doing basically a Missouri state plan, e-state plan, but they're going to be there, or they live there now and they're moving back, or they're moving there for whatever, I will use those forms because they're good. I think that ours will work in most jurisdictions, however. So I'm going to talk about wills briefly. A will, typically, is going to be a document that's going to instruct the court as to what needs to be done in a decedent's estate. So we are talking maybe about a small estate, maybe about a large estate, but we're talking about a decedent, not a conservatorship or a guardianship. Why a will if we're trying to avoid probate? Well, there might be assets that you just forgot about. Cars, you have to get a title reissued, as I mentioned earlier with regard to transfers on death, you have to get the title actually reissued to have TOD printed on it. You can't just scrawl it on there. And so cars sometimes are left out to go through probate. If you have a will, you make sure it gets to where it was supposed to go. If you don't have a will and you don't name beneficiaries in your will, the code is going to say where it goes. So intestate succession, succession without a will, beneficiaries without a will, they're going to be defined in here. Most people don't want the statute saying who gets their stuff. Me, 2 kids, I mean, I know my wife and kids are going to get it, but I don't want the code to tell me that that's going to happen, and I still don't want to go through probate. But I've got a will. My will says everything goes to my trust. So I keep all the plumbing in place. So it's just a conduit, kind of a safety net, belt and suspenders, what have you. Checking accounts we spoke about before. Sometimes people leave them out of a trust. Sometimes people don't want to put a joint owner on them. Well, keep it under 40, but the will make sure it goes to where it's supposed to be. And sometimes there are long forgotten accounts.
Both a car and a checking account, is some of that 40K?
They stack. So we're talking about, the question is if you have multiple assets, it's the aggregate. So in total, are they worth $40,000 or more, including after you subtract the debt? So it's net value. Will can allow a personal property list so that it doesn't have to be executed with all the pomp and circumstance of a will. You can have, if it references it, you can have a personal property list just signed saying, you know, Susie gets the framed picture of me. God bless her. Very, very rarely will I do just a will. In almost all circumstances, I am going to have a trust as well. The one thing I want to cover with wills, I'm going to skip over a couple pages. The one thing I want to cover with wills is a will for people who have minor children. You can nominate guardians for the minor children. So forget about assets. Even if there are no assets to be probated, the will is the only way that you're going to be able to tell the court, here's who I want to take care of my kids. So a will is very important for that reason too. You can't do that in a power of attorney. A power of attorney, I can say who I want to be guardian or conservator for me, but if I want to talk about my kids, I got to do it in a will. My kids? Not much. Okay, so let's talk about trusts. A trust document typically is going to be revocable, meaning it can be amended, modified, revoked at any time by the grantor. The grantor is going to be the person creating the trust. For most married couples, I'm going to create a joint revocable trust, meaning that husband and wife create it. Husband and wife will be co-trustees, typically, with independent authority to act, so they don't have to act together. So if there's a checking account in the name of the trust, one of them can write a check. They don't have to both do it. Revocable trusts are not going to have their own tax ID number. they're going to have you can use your social security numbers. For almost all purposes, a trust, a revocable living trust, is going to be totally disregarded. It's going to change the name on top of accounts, otherwise nobody cares about it until the grantor is either dead or disabled. That's when it matters. The reason it matters then is because you've named a successor trustee. It's like a company. If the trust owns a brokerage account at Merrill Lynch and the grantor is now disabled, there's a successor right there. And the trust itself is going to say what disabled means. It may mean that the successor trustee says they're disabled. If that's what it says and the successor trustee says, yeah, they're disabled, that's it, you're done. No court, no doctor, you don't need it. Depends on what it says. I draft it a lot of different ways, but if that's what it says, that's what it is. You're not going to probate. You have successor trustees there to walk right in and take control of the assets. Sometimes there are reasons to do separate trusts. Those reasons are fewer and further between now, because the estate tax minimum has gone so high. So at $5.42 million, most his and hers trust, I will call them, are going to be created for estate tax planning purposes. There's just not that much planning going on anymore. So what's going to be in a trust? We're going to name your trustees. Yes, sir.
If you have, you set up individual trusts for husband and wife many years ago, should you change it now that the laws have changed a little bit?
The question is whether, if there are dual trusts for a husband and wife, separate trusts set up years ago, would you change it? Typically, I don't. I mean, I review estate plans all the time, and if somebody comes into me with dual trusts, unless there's a compelling reason to do so, and sometimes it's just ease of administration. If we want to make it easier, we'll collapse them into one trust. The problem with doing that is you've probably got assets funded into this trust and assets funded into this trust. If you collapse it into one joint trust, you got to move all the assets now. I don't want to do that. I'd rather just leave them that way. And again, as long as the plumbing's right, it's fine. It's kind of inconsequential, probably. Name of successor trustee. So typically, co-trustees, husband and wife. If you're married, grantor, single, sole trustee, you would need to name successors. I typically suggest that people name individuals and then have a financial institution at the end. It's really just a backstop. You hope never to get to the financial institution. Some people want a financial institution up front because they want to turn over to the bank now. You have significant assets. You don't want to deal with them. You want a professional to do it. Fine. There are trust companies who do nothing else but manage trusts. They cost a fortune, but whatever. If you want to spend the money, your business. The authority. Well, I'm going to skip over payment of taxes and expenses. You name beneficiaries. What good's the trust if you're not going to name your beneficiaries? And again, this is where the plumbing can get intricate if it needs to. Specific bequests. Stuff. I want, again, I'm going to give away my portrait because it's the most valuable piece in the collection. I want that to go to so-and-so. I can do that in the trust. In some of my trust instruments, I will draft in language that I said that you could have in a will that says a list of personal property might be found with this trust. So that way, the list can be changed without coming to me to do an amendment. As long as it's prepared and signed and dated, it can be changed out whenever it needs to be. Nobody needs to pay me to do it. A general devise. A general devise is the gift of cash we were talking about earlier. A general devise will come out first. So the stuff specifically identified, it's now gone. If a specific amount is now identified, or if it's identified anywhere, it's going next. So once you give the stuff and the specific amounts away, you'll probably talk about you're talking about the residuary. The residuary is going to be everything that's left. And the everything that's left typically is going to be done by fraction or percentage. If the general devises and the specific bequests wipe everything out, the residuary is just, they're not going to get anything. They are going to come last. The residuary always comes last. So when people come to me and say, well, I want to give X dollars to, my nephew over here, and I want to give the charity some money, so I'm going to give them Y dollars, and then I know there's going to be a ton of money left, so I'm going to leave the rest to my children. I always remind them, you have no clue what's going to be left because you don't know when you're going to die. You may end up in a nursing home for 15 years, and now everything you have left is going to your niece and the charity, and your kids aren't getting anything. So I always tell clients, you gotta think about that stuff. Make sure that you got, again, the plumbing, make sure that it's right. And again, order of death, we can plan for that now, right? We're doing, if we're in a trust context, I can do page upon page about begats and if and whether. Typically, it's going to be, I'll use myself as an example. My wife and I, our joint trusts, our assets go to our children in equal parts per stirpes. So it's pretty easy, short language. One of them dies. Again, my son's got kids. He doesn't. He's 7. I hope he doesn't. But if he had kids, they will get his share per stirpes. So they get his share. Our daughter keeps her share. But those beneficiary provisions now can get really complicated. You can say, well, and I have clients who do this. They can say, well, we don't have kids, so we want to make sure we've got this litany of nieces, nephews, friends' kids that we want to go to in different percentages. But if our nephew Susie dies, we don't necessarily want her kids to have it. We want her share to go to someone else. So I could have a whole tree of that. And then finally at the end, I mean, they get tired of me at some point, and they say, whatever. So I do a catch-all at the end. It's either, none of these people are left, and that interest goes to heirs at law, whoever they might be. Or we have a charity at the end and say, okay, well, if all these people are gone, then it goes here. But it's a lot easier to do that here than it is to do it on a little change of beneficiary form that's about the size of a novelty dollar bill. Minors. Or even if people are not minors, not minors, but young people. Age of distribution. 18 is pretty young. You may not want somebody to get all their money at 18. If you're in a conservatorship context, that child is going to get that money on their 18th birthday. The law says so. You cannot avoid it if you're in probate. In a trust, you can say that the trustee is going to hold it until they're 50 years old. It's up to you. I did have a client once who said 45. I thought that was sort of old. It was nieces and nephews, and I think they were bums, but whatever. But you got to have an age, or you can have ages. So not unusual that I'll see a third at 25, half of the remainder at 30, 100% of what's left at 35. Not unusual. What I find myself constantly reminding clients is that if assets are being held in trust for a minor, or not a minor, but an adult who they're worried about, or they just don't want them to get a big fat check, the trustee will still have access to those assets to take care of that beneficiary. We usually use an ascertainable standard that is the widest, broadest discretion. Health, education, maintenance, support. What that basically does is it gives the trustee the authority to spend that money on just about anything. So, and I also include, I mentioned this later, I also typically include in my trust that the trustee can make those distributions either to the beneficiary themselves, or if they're under the age of 18, or they have a guardian. Maybe they're disabled or incapacitated. They have a guardian appointed to their guardian directly to a vendor. You can pay the rent directly instead of writing a check or giving cash. But the standard also allows the trustee and the beneficiary to be the same person without breaking the trust, which is important, for example, for a spendthrift provision. A spendthrift provision in a trust is a provision that says that as long as the asset is held in trust and the beneficiary doesn't have a right to go to the trustee and say, give him my money, that beneficiary's creditors can't get at the money. So they're protected. If they've got a gambling problem, The casino can't come to the trustee and say, we know that you're holding $400,000 for this beneficiary, pay up. Trustee's going to say, no, it says spendthrift right here. And frankly, that's all it needs to say, is the word. Our code says, if it says the word, we get it, we know what it means. Yeah.
When the beneficiary, if you have, say, an income-producing trust and the beneficiary is spending an awful lot of time, can you give them remuneration to the beneficiary, like you have to,
You talking about the beneficiary or the trustee?
the trustees?
Okay, so the question is, if the trustee has a lot of work to do because it's an income-producing trust and you have beneficiaries, and the trust has got legs on it and it's going to be in existence for a while, can you pay them? The answer is not only yes, and you can indicate in the trust exactly how they're going to be paid, but the default is, if you don't say anything, our trust code says that they're entitled to a reasonable fee for whatever work they're doing. What's a reasonable fee? I don't know. I mean, I could argue for a lot, I could argue for a little. What I typically do and what I typically find is that most trusts are going to say either that the trustee is paid in accordance with the fee schedule in place at a particular bank, usually the bank that is the last trustee to be named. That fee, by the way, most banks for administering trusts, the fee is going to be around 1% a year, give or take. 1% a year, give or take. That 1%, I was talking to a large national bank recently, and theirs is 1.4% a year. Sounds like a pretty good fee to me. Sometimes trusts will be written to say that if the trustee is a relative of the grantor, they're not entitled to a fee at all. They're entitled to reimbursement of reasonable expenses, but not entitled to a fee. Most of the trusts that I write are either going to keep that fee provision in there that says the bank's schedule, or it'll just go to the default reasonable fee. In my view, if a child, for example, is serving as trustee of a trust and they're administering the trust for a little while on behalf of their siblings, why shouldn't they get paid? And if they feel like they're getting paid too much, well, hopefully they're going to be reasonable and say either, or they don't need the money. They may say, you know what, I'm just not going to take it. Or they take it and they give it to their kids or whatever. But I mean, if the work's being done, I've seen it, with too much frequency litigation matters where the trustee's got to do a ton of work and cannot get paid. And they also don't want to give it up because it's their sibling who's suing them. And if they give it up, the sibling's going to be the trustee, and they don't want that. So that happens quite a bit. Yeah.
I've got a trust, husband and wife. The wife dies, the trustee is the husband. And the wife's trust names Eddie, her son, their son, at the age of 18, to get distributions from her trust. Can the trustee, can I change her trust then?
So
Modify it?
are there two trusts or one trust?
Her trust, my trust.
Okay. So we have a situation, I'm just repeating the question for the video. The situation where there is a husband's trust and a wife's trust. Wife dies. Wife's trust says that the son of the couple is entitled to distribution at the age of 18. The question that you asked was, can the trustee of wife's trust change that provision? The answer is it depends, because we in Missouri passed 3 years ago, maybe, an amendment to the code that allows for the appointment of a trust protector. The trust has to talk about it. If the trust includes the appointment of a trust protector may, if the trust says so, allow for the trust protector to actually change the beneficiary. So if the trust says the right things, the answer is yeah, probably, but it's going to have to say some really specific stuff. In my experience, those trusts of a married couple almost always are going to provide for the spouse first before they provide for the child. Even if, and I'm getting a little bit more complicated here, there are often provisions in trusts of married couples, or if there's let's say it's a husband and wife, wife has a child, they don't have any children together. The wife's trust might say, well, when I'm gone, husband is going to have these assets to take care of him. Those assets are going to be maintained for his exclusive benefit as long as husband is alive. However, the trustee is not to make any distributions to husband unless husband can demonstrate need. So we're going to look at husband's resources to see whether he actually needs a distribution, and only to the extent that it is to satisfy the manner of living to which husband has become accustomed. So if he drives an Escort, we're not buying him a Lamborghini. And, yeah, sorry. So there are restrictions on it. Now, in a Q-tip provision, real Q-tip provision, it's qualified terminable interest property. It's qualified because it's qualified for the marital deduction. I'm talking about estate taxes again. It's just, but it's terminable because it's there for the husband as long as he's alive, but he doesn't get to decide. He's not going to be the trustee in most instances, or at least not sole trustee. And then it will say whatever's left when husband dies goes to son of wife. Now, wife's trust internally may actually say whatever I have gets split 50-50. 50% goes into this Q-tip trust for husband, and 50% goes directly to son. I mean, again, we're talking about a contract. You can adjust this plumbing any number of ways. There are a lot of things you can do with it. I ask my clients when they come in, particularly if I know if it's a unique family situation, well, what do you want to do? What are the goals here? I have clients who have 2 children together, and he has a child from a previous relationship. They have 2 trusts. His trust provides for her. It does basically what I just said. It doesn't split out 50-50, but he does have a Q-tip trust just to make sure. She is taken care of. There's no question. But he also wants to make sure that if he left everything to her outright and she got remarried, his son from the prior relationship may just be cut out completely. So he just wanted to make sure that didn't happen. Everybody understood. Everybody was on the same page. We create a mirror trust that say exactly the same thing so that her money, and she has some of her own assets, that son from a previous relationship, actually, I think she included him anyway. He's basically her son now, too. She included him anyway, but she didn't have to. She could have kept him over here in his trust. So, a million different ways you can take care of some of these. Did I answer your question? That was a long way around. Okay. Trustees' obligations. There are certain obligations. The trust is going to give obligations to the trustee. It's going to be fairly specific about what the trustee needs to do, but more so with what a trustee is authorized to do. In most instances, in a simple trust scenario, I've said the word, 80 trillion times tonight, it's trust. I mean, you're not going to do this unless you have some faith that it's going to be carried out right. The code gives backup with the default provisions, and the document's going to give more specific direction as well. But most of the time, there's going to be a generous amount of authority and discretion vested in the trustee. So the trustee can do what the trustee thinks is right, always with that overlay of best interests. It's always got to be in the best interest of the beneficiaries. But some of these things are going to be included specifically. Investment provisions, for example. The default is that investment provisions must be made the way a prudent investor would invest assets. It's not an educated investor. It's not a dummy off the street. It is a prudent investor. There's a whole chapter in our statutes that deals with what that means. I don't get it, so I'm not going to talk to you about it. But basically what it means is prudent investor. The probate division requires the same thing, basically. So what we tell people is, look, you can invest some in equities, but you can't invest everything in equities. You can invest some in bonds, but you can't invest everything in bonds. You can keep some in cash, but if you do it, you better make sure it's FDIC insured, which, by the way, is a $250,000 limit per depositor per bank. Diversification of assets. The trustee is going to have the obligation. Some trusts are going to have one giant asset that is the family farm, okay? And maybe that takes up the majority of it. And there's a provision in the trust that says, we want you to hold on to the farm, which I would caution you against, by the way. It's a nightmare. You can hold on to the farm. Well, as long as it says it, then there's basically a waiver of that duty to diversify. Now, if holding on to it is not going to be in the best interest of the beneficiaries, forget about that waiver of the duty. The best interest has got to prevail. So the trustee is always going to have to constantly be doing a reassessment of whether whatever they're doing is in the best interest, no matter whether the trust tells them to do it or not. Advisors, investment advisors can be named in a trust, which I'm seeing more and more frequently. That my money's here, trustee, I want you to keep the money there, and I want this guy to give you advice. Well, that's great, but if that guy ends up getting arrested for securities fraud, maybe not such a great idea. Certainly wouldn't be in the best interest anymore, but sometimes giving that direction, again, I favor flexibility, but if my clients want the trustee to do one thing and they don't want to give them any option, okay. Accountings. Accountings under the code are required to be given annually, and they've got to be fairly robust. They've got to have all statements of all income and expenditures. A trustee is obligated under the same provision to respond to any reasonable request for information regarding the administration of a trust. A trust instrument, however, can draft around that a little bit. You know, it can require not so robust accountings. It can require accountings to go to some other third party who will have the obligated trust, like a trust protector, which I mentioned earlier, that has the obligation to review the accounting and make sure that the trustee is staying on track. Trustees' fees we talked about. Other common provisions will deal with real estate, for example, making sure that a trustee has the authority to buy, sell, rent, lease, mortgage, real estate, the authority to borrow money. If a trust is going to be in existence for some long period of time, because it's a generation skipping trust, for example, and you know that the beneficiaries are going to be fairly young when the trust becomes irrevocable upon the death of the grantor, you may want to have borrowing provisions. There may be real estate assets on which we need to borrow in order to take advantage of markets. Contracting on behalf of the trust, et cetera. I think this is probably germane for this group. A commonly encountered special provision that I have been putting in trust, particularly over the past 5 years or so, is a subchapter S provision. If a trust becomes an owner because of the death of the grantor of an interest in a corporation or other entity that has elected subchapter S treatment under the Internal Revenue Code, that trust has to qualify in order to hold that interest. I'll give you some context here. I had a client who owned shares in a bank, a small bank. That bank was a subchapter S corporation. There were a number of other shareholders in this bank, okay? Subchapter S basically means that it's being taxed as a partnership. So all the money is going straight out, right? Straight out to the individual owners of the stock. Well, as soon as the trust became an owner of the stock, the general counsel for the bank absolutely panicked because he looked at the trust and he said, this does not qualify to hold subchapter S stock. We're going to have to go to C. And they didn't want to go to C. It was going to cause total havoc, not only for the company, but for the owners of the company, the shareholders. There were not these subchapter S provisions in the trust itself. However, we were okay because there was only one beneficiary and she had to get all the income all the time, and that was the surviving spouse. So she basically was the beneficiary. Getting all the income all the time could never be held in trust anyway, so everybody was satisfied. Everybody stood down. There was no fighting. However, now I will ask clients that very specifically, especially if there's going to be this Q-tip provision, for example, where I know that it's going to be held in trust for a while. The income might flow out, but I know it's going to be held in trust. I'm going to put that subchapter S provision in there to make sure that it will either qualify, the trust will either qualify as an ESBT or a QSST. Don't ask me what they stand for because I don't remember. Subchapter S. Where in the world was I?
Is it hard to set up a trust for this real estate? You have a lot of real estate. Is it How hard is it to set that trust?
Well, here, I'm going to get to the funding in a minute. Setting up the trust is basically just having the instrument prepared, appropriately prepared and executed. That's it. It's not going to do anybody much good unless the assets are actually in the trust. So how do you do that? For financial accounts, I write a letter of instruction so that my client can take that letter of instruction to the bank, and it will tell the bank, put my brokerage account in the trust, retitle it. Put my checking and savings account in the trust, my money market in the trust. The same letter of instruction can be sent to life insurance companies to let them know, send me a change of beneficiary form so I can change the beneficiary on my life insurance policy to the trust. As I mentioned before with regard to qualified assets, we are not putting those in the trust. Instead, the trust might be a beneficiary, but really a spouse or individual should be named as beneficiaries on it. On a real estate, I would prepare a deed for my clients and record the deed. The deed just says it's going from husband, wife to husband and wife's trust.
Real estate, you have to get somebody else from a different state to do that.
In a real estate in a different state, sometimes you have to have a lawyer's name on a deed for real estate in a different state in order for it to be recorded. Sometimes, now, I would never practice law in another state where I'm not licensed. However, some lawyers might find a deed online for a different state or contact a lawyer that they know in a different state, have it prepared, and get it recorded. Sir?
Does the trust then have to, say you died, the trust pays over, do they have to pay income taxes if they become an entity themselves?
So here's what happens upon irrevocability. When the grantor dies or the surviving grantor passes away and the trust becomes irrevocable, it is now its own tax entity. The trustee should go and get a new EIN, a new tax number for the trust, and should take all the trust accounts and change them so that the social security number of the deceased grantor is not on them anymore. Instead, the EIN is associated. However, there really is no income tax ramification to any of that. All you have now is you just have the income that's being earned on those accounts, instead of being reported to the social security number of the individual, is now being reported to the EIN of the trust. So whatever income's coming in, now you just have a different entity paying the tax. But the transition from individual to trust, it's a taxable event from estate tax purposes, for estate tax purposes. And the importance there is that your basis for capital gain purposes, let's say that I bought a house for $100,000 that's now worth $1 million, okay? If I gave that house as a gift to my kids before I died, they take my basis at $100,000. So they have a $900,000 gain they're walking around with. If I die and they get it because of my death, either by beneficiary deed or it's in the trust and they get it because of my death, their basis is now $1 million. It steps all the way up to date of death value. Now, that value may grow after my death before they sell it. They're going to have gain on that. But their basis is now with a value at the time that I died because it's subject to the estate tax. But that only matters if I've got $5.4 million. Yes?
What do you do with a fire resident, as far as titling it? You've got dual trust, which husband and wife each have separate trusts.
So the question is, how do you title it? How do you title real estate, fund it into a trust, and title it a husband and wife have separate trusts? Again, I'm going to sound like a broken record, but it depends. I have clients, for example, who he owns a small business, and that small business potentially has significant value. We took that small business and put it in his trust, and that's the only asset in it. We took the rest of the assets and put them in her trust. And they're still totally unequal, but that's the best we could do. So her house has the trust, her trust has the house in it. However, you can actually split the deed and say his trust owns half, her trust owns half. And that way the value's split. But there may not be any reason necessarily to split the value. So we were talking earlier about if I'm reviewing a trust and it's a husband and wife have separate trusts, am I going to redo it? No, probably not, unless there's a compelling reason to do so. Well, let's say they bought a new house. How do I pick which trust to put it in? Well, it may not make an ounce of difference. But if it does, depending on what the trusts say, if it does, that will guide what we do. And maybe it's half and half, maybe it's his, maybe it's hers. Maybe we do a beneficiary deed outside the trust, probably not, but I don't know. I mean, it just depends.
Another question.
Here, 1 second. Yes, ma'am.
What recourse do you have if the trustees, if it's a dual trustee, or I was a trustee on my child's trust, if my ex-husband had the trust, he died, and it was me and the bank. And the bank refused to pay bills, but I didn't know what my recourse was. What would my recourse have been? They were medical bills.
So the question is, co-trustees of a child's trust,
Not a minor.
not a minor, but co-trustee of a child's trust, one trustee is a bank, one trustee is mother. The bank is refusing to pay certain bills. What recourse does mom have to try to compel the bank to pay certain bills? Well, it depends on what the trust says. If the trust gives absolute discretion, and it's 2 trustees, then each trustee has veto authority, okay? Now, if what the bank was doing was unreasonable, and it would have to be a serious breach under the code, a serious breach, then the trustee can be removed. There can be a petition, litigation to have the trustee removed. In some circumstances, the beneficiary can have the trustee removed, or the trustees, or the beneficiary's representative, whoever that might be. A majority of the beneficiaries can seek to have a trustee removed. In my experience, corporate trustees don't want the drama. So if there's a suggestion that they're going to be removed, and if a different bank is going to, it may require another bank to step in, they'll let it go. Now, if they're getting a giant fee, they may not. That's just practical. But if now, most banks are not, in my experience, they're not going to be unreasonable. They may not be terribly responsive, but they're not going to be unreasonable if there's a request for a distribution. But remember, they're covering their butts too. They don't want to get sued. So they don't want to make a distribution and then have somebody come back later and say, why'd you do that? All the money's gone now because you were spending it so unwisely. So they're in the business of making money and limiting liability.
And they're not required to, within a certain period of time. For instance, it was a suicide case. So money had to be paid to get medication, and they just wouldn't pay it, so I ended up having to pay for it. But they had, but if they aren't compelled in the time frame or anything to respond, they kept putting, like months, it would buy months.
That, to me, the way that you're presenting it to me, the suggestion is that the bank was just non-responsive. That to me suggests a breach. I mean, they have to communicate and they have to tell people why they're saying no, if they're saying no. At least they should. And I think that doesn't smell right to me. And I think rattling their cage may have gotten you somewhere.
It did.
Yeah.
Somehow I think I heard something different once or twice. In a checking account that's beyond the limit.
Use the mic.
Yes, I'm sorry. So in a joint checking account, I thought I heard said a few minutes ago that it needs to be in a trust, okay? What I know, what I've been told, and this is again by the bank, that if when signing into the checking account, you list how you want your money, who it's to go to, if it's a joint and then in children and it's divided up, would that be enough, or does it need to be in the trust?
So the question is, if you have transfer on death or other non-probate designations on a checking account or a bank account of any sort, is that enough? I would suggest probably not. Even if you're under the $40,000 limit, you have to remain concerned about disability. So remember that I said in the event of disability, even on a joint account where somebody else has the authority to get in and get out, if there's a petition to have somebody adjudicated, the court's going to say, well, what are their assets? And if one of the assets is the joint account, well, dagnabbit, it's in probate. Now, if that joint account is now in the trust, and if provided the trust has the same plumbing that the joint account would, it's going to the same people, if it's in the trust and there's incapacity, you don't need the court. You're never going to need the court because you've got a trustee there.
Thank you.
So I think that most assets should end up in the trust, And if you've got some non-residential piece of real estate that's in a limited liability company, the limited liability company should be owned by the trust. All roads should more or less lead to Rome unless you have those qualified assets where an individual beneficiary makes sense. I'm out of time. So thank you all very much. I'm sorry I went kind of